I did during the lunch hour. I reread State versus Jensen, 331 Wisconsin 2nd, 440. That was the Court of Appeals decision. That was decided December 29, 2010. I'm not going to get into the issue of confrontation and the letter and all that other issues that were decided later by the Supreme Court of Wisconsin and the United States Supreme Court. But this case that I just cited talked about the penis issue pretty extensively. And I'm shocked how many times they mentioned the word penis. And what did this case say? Now, this is guidance for me, and I like it because it makes my rulings a little easier. So what does it say about this evidence that we are trying to keep out? It's admissible as part of the panorama of evidence surrounding the offense. And it talks about numerous witnesses. It talks about the state's theory that before Mr. Jensen, this is the Court of Appeals talking, not me. Before Jensen murdered his wife, Jensen engaged in a campaign of emotional torture by repeatedly confronting Julie with pornographic photos. The evidence involved the relationship between the principal actors, Jensen and Julie, and traveled directly to the state's theory as to why Jensen murdered Julie. Then it goes on to say, it also goes to the issue of the computer, because there's an issue of pornography on the computer, and that Mr. Jensen regularly surfed the computer regarding the issue of pornography. So the computer is also an issue in this case. And then it also, you know, we're going to have other witnesses that are going to testify. The state talked about Kelly Jensen, and I believe her last name is different now, but it also talks about Kelly Jensen's testimony. And it goes on to say, it tended to show that Jensen had a long-standing fascination or obsession with penises. Given this, was likely the one responsible for the penis-focused photos stored on the home and office computer and left around the Jensen home to emotionally torture Julie. Each category of evidence Jensen complains upon was properly admitted. So it's coming in.
I'm not arguing as to relevancy.
It's coming in.
No, I get that.
You argued this morning that it was relevant. So don't tell me now it's not relevant.
This time I'm not
I'll
arguing
get the transcript.
relevancy. I'm not arguing relevancy.
You argued that this morning. So
did.
we're done. Bring the jury
I'm
back.
not arguing hearsay.
You argued a different objection this morning, and now you're saying I didn't say that.
No, I'm saying, Judge, I agree with you as this morning. I'm not
You can't
arguing,
have every argument you want and get the last word in.
Judge, I'm not arguing as to relevancy from Ms. McGinnis. I'm arguing that it's hearsay. She just testified that she wasn't sure if she heard it from Mr. Nearing or heard it from someone else. That's hearsay. And I don't have a right to confront that individual who may have said that to her because that person hasn't been called. That's the objection. I didn't object as to relevancy.
Are you done?
Yes.
Okay.